Thanks, Lulu. So this is just an overview today. During our first webinar, I spoke mostly about adjustment of status and what it kind of looked like to do an adjustment of status application or interview. And I kind of did the play-by-play of what it was from, the first steps of walking up to USCIS in Fresno, because that's what I usually do, all the way out to leaving USCIS, whether that meant in handcuffs or in with an approval. But we went over that in our first phase. Hopefully you guys were there for that. If not, then please reach out to us. I'm not going to be really touching too much on that, so I'm not going to give too much of an overview of what we went over last time. We're just hitting new topic today. New topic today is very different. We're going over what it looks like to file for applications of asylum in immigration court. So what I'm going to hit is kind of talking about what the difference is between immigration court with immigration with USCIS. Those are two different agencies that can adjudicate asylum applications. So we're going to talk about that a little bit. Then I'm gonna hit about what it looks like for the whole process of asylum applications. What that usually entails is getting stopped at the border, getting an NTA, showing up in immigration court, going to hearings, whether that's masters or individual hearings. Master being the basic 2 seconds that you're going to speak to the judge and then you get kicked out a couple months or years. And the individual hearing being the big, huge hearing, that's the evidence, that's the trial. That's where you get, 3, 4 hours with a judge, sometimes 8 to 12 hours with the judge to discuss your case. And then what happens afterwards? You won or you lost, you appeal, that looks like. Then I'm going to hit what it looks like to win an asylum application. What's the difference between a losing application and a winning application? I'm going to talk a little bit about changes under the Trump administration. It seems very similar to the first time around, but there are little, um, I guess, surprises that Trump came up with this time around. Going to talk about those a little bit. Last thing, we're going to talk about detentions at immigration court. That'll be a short discussion because there's not really detentions at immigration court anymore. There was scary stuff going on in the beginning of the administration, not so much now. That's kind of the overview that I'm going to hit, trying to keep it at about 70 minutes or so to allow for some discussions afterwards. If we can have some Q&A, that'd be great. Not sure about the attendees. Some of the names I recognize, some I don't. Some people might have basic questions. Some people might not have any questions. So I want to leave some space so that we can talk about that either at the end or when we have a break, when I'm switching topics, maybe a couple questions. So whatever questions you got, just put them in there, and then SIREN team, interrupt me if you need to interrupt me, because I usually don't pay attention to chats. I don't pay attention to questions. I just love to hear myself speak. So you guys should be used to that. Okay, so first one we're hitting is what's the difference between asylum applications in immigration court versus USCIS? So what usually will happen is you get an NTA to go to immigration court. Usually our fact patterns are somebody comes to the United States, they don't have a visa, they can't get in, they just got stuck there at the border, or they come over through the desert and they get stopped and they say, hey, I want asylum. And then immigration says, okay, what am I going to do with you, right? So if they can kick you out with an expedited removal, but if you're requesting asylum, they can sometimes put you in some type of expedited processing to see whether you're going to stick around or not. For this purposes of this discussion, we're saying yes, they're sticking around. So once they decide they're sticking around, they can either detain you indefinitely until you have your hearing decided, or you get kicked out and you're not held in detention, and they give you a hearing date. That's what happens to the majority of our consultations and the clients that we take. When it comes to asylum, when it comes to all my work at SIREN, I pretty much only am pretty basically a trial attorney. All I do is just prepare trials specifically for asylum. About 80% of the cases that I do are domestic violence based. We got some LGBTQ, we got some political opinions. We got a little mix of everything, but the bulk of what I do is DV related. That's what I focus on. That's what I want to do. So that's what I do. So basically, when people show up and they have a visa, they're here with a visa, they're traveling around, they want to file for asylum, they request it, you go through USCIS immigration. That's what you usually do. But for people that come here illegally or without documentation, usually they get kicked over to immigration court. That's a different process. They are completely separate. Immigration judges strip jurisdiction from USCIS, so you can't have jurisdiction in both. It doesn't exist. So basically, you're going to be in one or the other. That is critical because there's lots of people that don't know, hey, I got to file for asylum. They found the wrong place. They missed the 1 year deadline and they're kind of in trouble. So you just got to pay attention to that and know where you're at. For most of my clients, people that I'm kind of trying to use this webinar as kind of like a way to connect with you, you're going to be the batch that are people that come in without documentation. You got an NTA saying go to immigration court. It's going to say go to Concord, go to Vegas or go to Los Angeles or go to Sacramento, wherever, that NTA starts the process. And then you get the next step, which is your hearing date. When you get a hearing date, you're going to get a letter in the mail saying, hey, you got a hearing date. This is for your master calendar hearing. Two very big differences between master calendar and individual hearings. Master calendars are where you have basically about 2 to 5 minutes with the judge. Kind of similar to, let's say, criminal court. You go to criminal court, there's a whole flood of people in the audience, and you're just one of them. Everybody wants to talk to the judge. They don't have time to talk to you. They just want to kick it out and figure out what's going to happen with your case and move you along. It's calendar time by the end of it, and then they just figure out what's the next date. The immigration judge here is going to pretty much give you 2 master calendar hearings and 1 individual hearing. So the 2 hearings are very quick, 3-5 minutes, and then you get kicked out. The individual hearing is materially different. That is only you with your attorney, with DHS, prepared at trial. You're going to call witnesses. You're going to give testimony. You're going to have 3.5, 4 hours to be able to battle it out tooth and nail to get to the end and get a decision from the judge. So the 2 hearings are very, very different, prepared very, very different. Make sure you know which one you got. So at the master calendar hearing, first calendar hearing that you're going to have, you're going to go over that very first document you got, the notice to appear. The notice to appear usually has a couple little checkbox, just figuring out whether you entered with a visa or not, or whether you entered and just got caught at the border, or whether you were here at McDonald's and got stopped and got kicked into immigration court. They go over that. Not too important, right? At least until it comes to next session when we have bond proceedings. But for most of our clients, they're usually just jumping over the border and running over to immigration saying, please give me asylum, or they're approaching the port of entry legally, with everybody else that's coming in with a document saying, please, I want asylum, and they request it directly. That notice to appear, first document, says this is how you entered, 4 or 5 questions. Those questions are you a U.S. citizen? No, otherwise you wouldn't be filing for asylum. Are you from this country? And it'll have your country of birth. Yes, you're from that country. Did you enter with legal status? No, most of our clients are a no. And do you have legal status to stay here now? No. And the judge makes a decision and says, okay, based on this, I'm finding you inadmissible, saying that we can deport you. What are you going to do about it? And then you say, okay, well, we're going to file for asylum. There's other things that you can do. You can file for cancellation or removal. Most of our clients can't file for that because you got to be here 10 years. You can file for adjustment of status. You usually got to be married to a citizen or have a child that was born here, who's over the age of 21. Most of our clients don't have that. So usually for our clients, you're looking straight at asylum. So you request for asylum. Now, you got to file for asylum within the year. As soon as you got here, you got 1 year to file for asylum. Is it possible to do it after the 1 year? Absolutely. Is it very, very hard to do so? Yes. You got to find an exception, something that takes it outside of your control and it wasn't your fault. And that's why you didn't file for asylum in a year. And you got to convince the judge that you didn't have any control. Otherwise, you're done. So at these hearings, pretty much first hearing you're going to do is answering those pleadings, is what we call them. Here for our clients, if you are a client of ours watching this, just understand that we do not like you going to court because lots of people get detained there. Lots of people get scared to go there to get detained. So some people just don't want to show up, and it creates a lot of fear and anxiety, and it's just cruel. So what we do with our clients, and most attorneys will do this, is that we will do what's called written pleadings. Some of the people in the audience know what written pleadings are because they've helped me do them. Those written pleadings are when you answer all those questions written down and you go over them with the client signs the answers to them. I sign the answers to them saying I read it all back to them in their native language, and then we send it to the judge. That way they never really have that very first master calendar hearing. We tell the judge what we're going to do, what the answers are, and then we get the ball rolling. So then that kicks it over to usually the master calendar number 2. So then the judge might see the written pleading, say, it looks like we got all the questions we need answered. Let's kick it over to another master calendar hearing and figure out what we're going to do. Then for the next master calendar hearing, we got to have that application for asylum filled out, ready to go, and filed. What does that mean? Filled out, ready to go, and filed. That was different a couple years ago. That was different a couple months ago. What that usually means is sometimes you file a skeletal application, which means you put your name, your date of birth, your biographical information, basic information that you know, put it on your application. You kind of put a couple sentences explaining why you really want asylum, tell them why you're scared, what happened to you, and you file that. And you just want to get it done, get it, just keep it nice and dirty and just throw it all on there and get it filed because if you miss that 1 year deadline, you're toast. That's changed, and we'll go over those changes later, but now it's going to be a different process. Now we just don't want to throw your information on there and file it. We want to slowly fill out everything. We want to make sure your addresses are right. You want to make sure your work history is right. We want to make sure your school history is correct. We want to make sure every time you ever left your country, whether it's going from Honduras to Costa Rica to visit your uncle when you were 3 years old, everything needs to be perfect. There's a new case called Matter of Car, where if your application is not perfect, if it's not filed and if it's not clear and it doesn't kind of state what your claim is, and it's not approvable the way that you filled it out, then they could deny your application without ever getting to that next master hearing, without ever getting to your individual hearing. They just deny it and you lose. So what we do is that we slowly go over the application line by line, make sure everything's filled out perfectly. If you're a client of ours, for the love of God, just put everything on there. Okay. We care about whether you worked someplace for 3 months. If you're from Michoacan and you went to Oaxaca for 3 months to work, that is important. We need to know that. If you change your story later on, that's how applications get denied. Later on, we're going to talk about winning and losing applications. That's the difference. You want to be transparent and you want to be thorough with these applications. You got to have everything set, ready to go right off the get-go. So make sure that you're being very detail-oriented with your attorney and their assistants. Make sure that we're filling out that asylum application absolutely as best as we can, and make sure that we check off that box saying that we're filing for asylum and we did it right. What we tend to do, like I said the first time, is we don't want our clients going to master calendar hearings if it's not required. So next step in your immigration court case is, what do you do after your first immigration court hearing? You already did your pleadings. Now what do? You're going to file for your asylum application, right? And you got to show a declaration, which is going to be pages saying specific information about what happened to you, what makes your case special, all your information, checking for internal inconsistencies. We got to make sure you're solid on this. So put all that information together and we file it. We don't want you to go to that second court date because, like we said before, some people get scared, some people get nervous, some people get detained. We don't want you guys going through that fear. So what we usually do is we file that application for asylum with a very good declaration. We tell the judge, we're going to file everything else before the hearing date. Can we just kick this over and just cancel the second master hearing and just set it for an individual hearing? Set it out maybe 90 days, maybe we set it out 3 years, I don't know. But the judge is going to come up with a new date, vacating your hearing date, vacating the master, vacating the second master, setting it to an individual hearing. So by the time you get to the individual hearing, this is where the bulk of the work happens. This is where you get into the weeds of it all. You get everything muddied up. What I typically tell people is that's where you get into the more gruesome elements of stuff. I won't word it the way that I usually word it. You get into all the difficult gut-wrenching stuff. That's what we want to get into. Okay. So when you get to the individual hearing, we're going to have lots of filings that we do. This is where you really, really, really got to work with your attorney. So what we usually do is we got to review your asylum application again. We got to review that declaration again, make any changes to it because it's been a year or two, and every single time you speak to your attorney, every single time you speak to one of the assistants, every single time you talk to your neighbor or your sister or whoever about what's going on with the case, you're going to remember a little more and a little more and a little more. And what turned out being a two-page declaration in the beginning, by the time we get to the final hearing, might turn into 8 pages because now every single time you go over something, you're going to remember a little more. That's normal. That's we have documentation from specialists that we can submit to the court, and I do submit them to the court, talking about how when you go through trauma, you tend to forget things. And that's normal for the brain to say, I remember this happened, I remember this happened. Your brain will naturally fill in the gap. Even if you don't really remember it, the brain will trick you into thinking you remember it. But the more you pry and the more you revisit and re-traumatize yourself through living these experiences, then the more it's going to kind of trigger those actual memories and you're going to remember more and more. Those details are super important. Super important. That's usually the difference between getting deported and getting asylum. We'll get into that a little more later. But what you want to do is you really want to work with your attorney in between the second master hearing and that individual hearing. What you're going to work on is you're going to beef up that declaration. Make sure this is the story of your life. That declaration is essentially what I tend to write it as I tend to write it as a summary of the testimony that you're going to give in court. There's a lot of arguments from attorneys as to what that's supposed to look like. Some attorneys say it's supposed to be more of like a deposition, saying this is exactly what we're going to write about, and this is exactly what the testimony is going to be, and the testimony is just going to be me reading my declaration, essentially. I don't do it that way. I don't prepare my clients that way, but we're kind of moving in that direction. You really want every little detail flushed out and on that paper when you submit it. You're going to also have to file a lot of supporting documents when you're filing for asylum. We're not just talking about your birth certificates, marriage certificates, divorce certificates. We need that. That's by law required. They call it the Real ID Act. Your judge is going to hit this and you're going to like, what the hell is he talking about, right? The Real ID is saying that if you got some evidence, it's better be the real deal. You better prove it. And if you don't prove it, you're going to have to explain a good reason why. So if you have a passport, then you produce it. If you have old passports, you better produce those. If you have old passports, but you only have the new one, then the judge is going to try to figure out why. Why are you trying to hold on to that information? Is it because it was stolen and you don't have it? Or whether you have it at home, but you just didn't want to bring it because maybe it shows that you left the country when you weren't supposed to, right? So you really have to have real good explanations for all of this stuff. So don't try to sugarcoat everything. This is the type of discussion that you want to have with your attorney way beforehand. So part of it is the declaration, the birth certificates, the identity documents, marriage certificates, all that stuff. All of that is extremely critical, especially let's say if you have an application for asylum, but your kids are on that application for asylum. Now, you should have an application filed for every single one of your kids too, right? Got 5 kids, you got one principal applicant, the mom, and 5 kids. That can get a little expensive sometimes. Some people don't have the money to file asylum and kick out I think that's $1,000. I don't know if it's 100 or 1,000. Somebody correct me on it. I don't really pay attention because I don't pay it, but it gets expensive sometimes if you're going to kick out this much information and all this money coming out. Some people don't have it. So what if you just have one application pending and you got 5 kids? If you don't show the birth certificate connecting, saying that's really your kid and it's not your nephew or something, then that kid's gonna not win asylum. You have to connect the dots. Real ID Act. It says you gotta produce it. So we want every birth certificate. We want every marriage certificate. We want every divorce certificate. I don't care if you got married to the same guy twice. You show that you got married, divorced, and married again. You got to show your passports, all the ones that are expired, all the ones that are not expired, all the ones you got last week right before the hearing date, you show them to the judge. Those are all the regular documentation that we're looking for. That's kind of the foundation of it. Immigration court is a little different, right? Sometimes if you see on TV, you see court stuff, you got somebody battling, somebody trying to find a way to win a case. You usually see on these television shows or on these movies, criminal cases, right? You got the district attorney that's brick by brick creating a story and showing the entire case. And then you got the public defender or the defense attorney that's trying to poke holes into these bricks to show that they're not as strong as they really are, and that kind of makes the whole case crumble away. Immigration court's kind of like that. It's just a little backwards because in the end, what we're really trying to do is we're trying to tell your story. This is all about you. You are the main character in this story. If this was a play, right? And we got different acts. You got the act one, which is all your birth certificates and all the biographical stuff. The act two, what harm happened, and three, what happened afterwards. This is your story that we're telling. And the story that we're building up is a story usually of trauma and harm and abuse and not having the support from law enforcement to protect you. This is a pretty big story that we're building up. And kind of like in those criminal cases where you got a district attorney that's building a case brick by brick, building a house, nice, good, strong house with a really nice, good foundation. We're kind of doing that, but we're not doing it against somebody, we're doing it for our clients. So in the same way the DA builds a case that needs to be strong from foundations all the way up, and every single brick has to be strongly laid in immigration court, even though we're not the prosecuting agency, that's Department of Homeland Security, it's kind of backwards. We're the ones defending the immigrant, but we also have the responsibility of building that case brick by brick all the way up, building that wall, building that house, showing how strong it is. In criminal court, they're really building a case against the defendant, saying how bad of a person, just trashing them, right? And showing the strength of their case and what harm happened. In our case, it's a little different because we're kind of building a case, but that person that did the harm isn't here in front of us. This is going to be in these DV cases, it's usually the spouse, right? So if you got female, let's call her Maria Guadalupe, and we got the husband Jesus. He beats his wife. She's feminist, so she tells him, no, don't treat women like this. I'm not going to do what you say. I'm not going to just obey you. You need to treat me like an equal. And of course the guy just machismo, just wails on her even worse because he doesn't like her speaking up. That's political opinion. That's somebody who, if they just rolled over and said, yes, honey, whatever you say goes, they wouldn't really get treated as badly. But they get persecuted because they get the extra treatment. They get the extra beatings. They get beaten within the inch of their life because they did not bend the knee and they did not say, yes, sir, whatever you say, sir. They tried to fight back using their voice. And because they use their voice, their political opinion, their feminist opinion, they got beat for it. That's the persecution. So we're building the case of this persecutor, this bad actor in Mexico or Honduras, wherever he is. We're showing how bad that guy is. And we're brick by brick showing this is a bad actor. This is the harm that he did to our clients. This is who our client is. This is who the family of the client is, grants this application. So when we're doing this, the main character of the story is you, the client. We need you to kind of step into that role and own that role. You didn't have a lot to say about the abuse that you suffered. You didn't have a lot to say regarding what help you were going to get from law enforcement, which usually is nothing. This is the opportunity to kind of take that power back. You get to voice your opinion. You get to say what you feel. You get to say why these guys are wrong, why they're I won't say they're bad actors. You get to be able to say what you feel and what happened to you because you said your opinion, why you decided, hey, I'm not going to put up with this anymore. Hey, I'm going to leave you, which is usually a big trigger, right? Big trigger for machista guys. Or if you're going to be somebody who speaks out against the government and you tell the government, no, screw you. I know this is my political opinion. I'm not going to go with what you guys say. And then they get police officers to beat you up or pick you up and torture you. It's because you're using your voice. Okay. When we're fighting for asylum, back when I said things that are important with your asylum, we got to get into the details. One of the things that we have to submit is country conditions, talking about what the situation is. If it's a political opinion, let's say it's somebody who is let's say they're against the government in Venezuela, right? if they're against the government of Venezuela, we want to show what it's like politically in Venezuela, right? We want to show all the evidence, country conditions, reports about, who's in power and how people get beat up, all that sort of, that's very basic, fundamental country conditions. We want to be able to show that that's important for the claim. Same thing with DV spouses. If it's domestic violence, we want to show what happens to DV victims in El Salvador. Is it like the US? Do you get a protective order and the guy gets absolutely thrown in jail for months and years if he violates it? No, it doesn't happen that way. We got to show that, right? But that's just the first layer of things. Those are just the first bricks. Next brick is what happened to you personally. Okay. Um, Jumping a little ahead of myself, I'm just going to jump into some of the reasons why applications get denied. What a lot of people come up to me and say is, have you ever heard about Michoacan? Have you ever heard about Apatingan? It's crazy there, right? You don't understand. It's vicious. The cartels, they got it all, and they're running like just tell the judge I'm from there and explain what happens. Yeah, that's called country conditions. Asylum applications that are based on country conditions, that's called a loss. Okay, that is a perfect way to lose asylum by saying, oh, hey, look at my country conditions, right? Look at what happens to people over there. Asylum isn't, are you from a place that bad stuff happens? Asylum is, are you from a place that bad stuff happens and what happened to you? Okay, it can't just be what happens to everybody. They can't just say, hey, everybody from Apatingan, just get on a bus and come on over. The whole city, the whole state, the whole country come right over because things are bad. No, what we have to show and what our job is to pry the information out of you, figure out what harm happened to you personally, and show if somebody else is from that community. If you get 5 or 6 people from your community, what makes your case different? What makes your case special? Okay, what did you say or do that made you get beat, not the guy down the street? That's what makes and breaks an asylum case. Those little details. When somebody says, no, I spoke up, right? I told the person, no, I'm not going to do what you say. Hey, oh, just because I'm your wife doesn't mean I have to have sex with you whenever you feel like it. No, I'm not going to do that. Then guy goes ahead and beats and rapes the girl. The police officer picks somebody up because they think that they're gay. The guy says, no, I'm not gay. He's like, no, screw you. You guys are idiots. Then the police officers get mad, then point a gun and force them to have sex with them or something. That's the type of stuff those are the really gritty, ugly details that we need to get into. That's, as I say before, hopefully there's no like bad stuff on this, but that's when I tell people you need to get into what I usually say is the bloodshed and tears of the situation. You want to get into that bad stuff. That's critical because that's what separates you from all the other cases for all the other individuals in your class, in your group, right? You got to be in a group, right? But what makes your situation different and special? What elevates it, right? You got to show your facts. When it comes to these cases, it's not the attorneys that win the case. We don't really do much. We're presenters. It's kind of like we're telling your story. We're in this play. We're the director, right? We're the director kind of showing what angles to show and what facts to show and using the client to give the testimony to put on their show and show what their situation is. But the facts are everything. You go then to law and anywhere. You do criminal law, you do family law, you do immigration law. It's all the same. The facts are what win the case. You're not just going to have a really good attorney that's just going to do fantastic things and make a loser case a winner. That doesn't happen. It goes based on your facts. So you have to open up and you have to be vocal and you have to tell your attorney everything. Because if you're one of those people that, hey, I was on a bus and the random cartel members went on that bus and they got everybody out and they beat me, then the question would be, why did they beat you? Did they beat anybody else on that bus? Were there any US citizens on that bus or was it all just Mexicans? Was it all just, Guatemalans that were on that bus? Did they, beat any women or was it men only? Did they try to sexually assault anybody? Did they try to sexually assault men or just the women? Why did they go after you? What words did they say? That's all very, very critical. Next up, okay, so let's go back a little bit. What I was talking about before was what's going to happen at this individual hearing, right? So you got to prepare this individual hearing. This is your story, right? You got to get everything. This is where months in advance, you got to start game planning with your attorney. What evidence am I going to use? We don't know. I don't know until I'm prepping with the client, be like, oh, shoot, we need this extra stuff. Can you get a letter from your mom, right? Did you tell your mom about you getting raped by this creeper guy? Did your cousin know that you got beaten and raped by a police officer because he hated gay people even though you're not even gay? He just sexually assaulted you because he thought you were gay just because you have a weird haircut or something. Those details are very important. And when you get on the stand and say, hey, did anybody else know about this? And you say, yeah, my cousin did. If we don't have a letter from a cousin, or we don't have a good reason that we try to get a letter from a cousin and didn't get it in time, that is a problem. So we need to get into all these details. We need to get into these facts. You need to have these conversations, lay out all the dirty little details of it and tell your attorney that. That way your attorney can document all of this information and start coming up with a list of about 10, 15 things. Maybe we want to get some declarations. Maybe we want to get some letters from the cops saying, hey, we called the cops, what happened? And then we get a letter from the cops being like, we didn't find nothing, right? We didn't even make a police report because, they didn't know the last name of the abusive person, right? Maybe they just arrested the DV guy and just threw him in jail, just threw him in a drunk tank and released him the next day. Getting documentation of all of that is very, very important. It shows an inability to police. It shows an inability to protect the victims. All of that is very crucial and can turn your case from a loser case to a winner case very easily, or turn you from a winner's case to a loser case if you don't get it and have a good reason for getting it in advance. Sometimes when we have these master hearings, sometimes they can be set up for, let's say right now, we got some master calendar hearings for this year. We might get the individual hearing in 2027, 2028, sometimes 2029. That is a long, long time. If you don't have a letter from your cousins talking about what they should have written out, the judge is going to say you've had 3 years to build this case. When did you go and ask your cousin for this letter? Oh, you waited till last week. Why didn't you ask for it weeks in advance? And you're going to say the attorney didn't tell me I needed it. The attorney will be like, yeah, I didn't know. So you got to get on this and you got to be proactive and tell your attorney, hey, this bad thing happened. This person knows about it. They can write a letter. They can testify via Zoom. They can be somebody to advocate for me, because nobody's going to make this case for you. It is on the applicant to show that you're eligible for asylum. The burden is not with you, it's against you, and you got to overcome that burden. So whatever evidence you can come up with, whether it's old text messages, whether it's screenshots of a police officer that threatened your life and threatened your family's life, or if it's a note written in blood that's left on your front door, right? And you got a photo of it, get a photo of it. If it's something that's in a different country, get a photo of that. I've had situations where a mother is supposed to write a letter against a police officer. They don't want to do that, right? You don't want to put a letter against a police officer, get it certified by some agency and put it in the mail and hope the police officers don't find it, right? Sometimes you tell the judge, hey, what we did is we've had the individual, they wrote the letter, that's the letter, they took a photo of it, they sent it to us via WhatsApp, and then they burned it. Why they burned it? Because they're scared, Your Honor. They didn't want to put that they don't want to put an envelope. They don't want to send it over here. And then you put that in a letter and you explain it to the judge. Okay, there's ways to make it work. But these are the differences between a losing case and a winning case. Now, when it comes to evidence that you need to file, we're going to submit a lot of country conditions, talking about articles, news articles. That doesn't make much of a difference because the judges know it already. They're judges. They literally will take classes on country conditions. They will sit down and put all the judges together and say, we're going to talk about Afghanistan. This is what's going on. And this is the type of claim that you see. They know the country conditions. You're not going to win a case based on country conditions. They know it already. So you got to show the country conditions, and then you got to show the declarations. You're going to show the evidence. What we're going to do is we're going to ask you for what witnesses we can have. Usually you want to have the main person as the client up there, maybe 1 or 2 extra witnesses of people that can testify. Those can testify via Zoom. Usually that's not going to work. 9 times out of 10, you're going to get 1 or 2 witnesses that are there in person, but The vast majority of the time, it's going to be witnesses who are the applicants, and you got to be the star of the show. You need to sell it, and the clients needs to shine on the stand. We need to put a witness list together talking about all that stuff and saying what we're going to post. If you want to have other people be testimony, you have to tell the Department of Homeland Security and the judge who that person is and what they're going to be testifying to. Everything that you submit to court needs to be submitted to the judge and to opposing counsel, ICE. We're trying to deport you. You need to give everything to them at least 30 days in advance, usually much, much more. You don't want to wait till the last minute. The problem with that is that if you give them your whole argument and you give them all your evidence, they're going to know everything. And the thing is, in courts, there are no surprises. This is not television, okay? There are no surprises here. You need to tell them what you're going to claim, and you need to tell them in advance, and you have to give them a chance to be able to rip your argument apart, and they will. So you need to be able to tell them everything. You need to put it in a declaration, give them all the experts, tell them what witnesses you're going to have. You're going to tell them what your witnesses are going to tell the judge and why that's important, whether they speak English or Spanish, all of that. No surprises in court. It's all about preparation. We always want to outwork the other party. That's how you win these cases. Let me see what else. I think that's about it. So that's pretty much what the differences are, going back to what it looks like from a master calendar hearing with the individual hearing. So first, master calendar, answering those first questions, written pleadings, right? Second is all about filing the application and setting an individual hearing date. Third hearing is going to be that individual hearing. The individual hearing, it's a trial, okay? Instead of having 5 or 6 days of trial, 15, 20 days of trial in criminal court, you got about 2 or 4 hours. Okay, that's usually what you got. There's a really good immigration judge. Geez, I'm missing her name right off the top of my head. She was a head judge in San Francisco for a long time. Can't remember her name, but she pretty much said asylum law is basically having a murder trial in a DMV administrative hearing kind of presence. Because instead of having weeks and months to put on all these people and to get into everything, show all the evidence, you can't show videos in immigration court. You can't show audio in immigration court. You just have to have it documented. You don't have a lot of witnesses that are showing up because you only got 3.5 hours to do it. Testimony that I always run is a minimum. I'm talking minimum about 45 to 90 minutes. 45 is insane. Realistically, it's 90 minutes. So if you got 90 minutes from me and you got 90 minutes of cross from the judge and Department of Homeland Security, all of a sudden that turns into 3 hours real quick. You're not going to have a lot of time to put this show on. So we got to be very smart and we got to be real intentional about all the questions that we ask, what we're hitting and why we're hitting it. Okay, all the details matter. So you got to be aware that you're not going to have a big, huge platform. That you got to be smart about what you say and how you say it, and your attorney is going to prep you, and they're going to have you, kind of break down on the stand the way that we want you to show you. We want to show the judge what's going on and who you are. When you get done with your individual hearing, the way I do it with my clients, right? I always tell the clients, okay, we're going to do your testimony first. That's going to be get introductions first, and we kind of get 15, 20 minutes of the individual hearing, just kind of doing housekeeping issues, logging the evidence, that sort of stuff. You have about 20 minutes of that. Then you get into the testimony. I put my client on the stand and we put him up there for about 90 minutes, take a break, everybody uses the restroom, gets water, comes right back. Then you have the opposing counsel, you have the Department of Homeland Security, that's the ICE attorney. They're there just ripping every single question that you had and ripping it up and just making you feel like you're just scum and you're just a liar. And, oh, well, you didn't say that in your declaration. Why didn't you say that in your declaration, but you're saying it now? Be like, well, because I wanted to say it now, right? Didn't put everything on the declaration. Otherwise, the declaration would be 50 pages long. Well, they're going to still rip you apart because you didn't make the declaration 50 pages long. That's just what ICE does. Don't worry so much about what ICE does. Just answer the questions, and then your attorney is going to be able to clean up the mess afterwards. Okay, we always get the first say, we always get the last say. So you're going to kind of, feel like you're tripping everything up and you're screwing everything up. don't worry about it because your attorney's going to be able to mop up the floor and clean everything up and clean up the last little facts and have the last say before we get into the final arguments. So I put on my case for about 90 minutes. The Department of Homeland Security rips everything apart for about 45 to 90 minutes. And the judge is going to have some questions. If the judge has questions, you better answer them and you better answer them truthfully. And you got to get to the point. The judges don't have time to waste. If the judge is asking you questions, it's because those are the questions that they're using to make their decision. They've already heard through our stuff and they're like, yeah, that's BS. They heard through all the questions of the department. Yeah, like, yeah, that's all BS. I know the 4 or 5 questions that I need answered, and these are them, and the judge is going to ask them for you, and you better answer them. You can't worry about whether you're going to win or lose. Just answer them. The judge is going to have their minds made up anyways. Just answer the questions. Okay. After that, then they're gonna have everybody calm down, and then we're gonna fight it out. So we have about 15 minutes for me, about 10 minutes for the department, and I do my legal arguments explaining why you should win asylum, and the department rips apart saying why, oh God, these are glaring huge holes, Your Honor. This makes no sense to grant this application for approval, and they just rip it apart, and then the judge renders the decision. What I usually tell my clients is, you're going to hear us arguing in English because we're not going to do all of that in Spanish. So there's going to be a point where you just hear us, me arguing a lot, the judge interrupting, DHS arguing a lot, judge interrupting. And there's going to be a spot where we just stop talking and the judge is just talking. And that means that he's coming up with his decision, him or her, right? So a judge making up the decision, you're not going to know what the hell's going on and you're not going to understand anything. And then what I do is I tell the client, the judge is going to tell me what the decision is, and you ain't going to know it. And then I'm going to touch the client on their hand. They're going to be sitting next to me. They're going to be confused. What the hell are you doing? Why are you touching me? I'm just going to touch them on the hand and I'm going to say, or I'm going to go like this. And that's me telling them what the decision is. That way they just understand it already. Then they'll either break down crying or they'll break down crying. Either way, there's going to be crying. So after that, the judge will explain in their native language with the interpreter what the decision is. Sometimes we win, sometimes we lose. Sometimes I'm 100% sure that I'm going to win and I lose. There's other times that I am 100% sure that I'm going to lose and I win. It doesn't really matter what I think. All that matters is what the judge thinks. So I always tell people, when you go through this, it's a very important day and it's a very important decision for your life. But it's not over. Because if you win, guess what? DHS, ICE, they're going to file an appeal and we're going to keep on fighting this. If we lose, guess what? We're filing an appeal and we're going to keep fighting this. So either way, the case isn't going to be over. It's going to continue, but this is still a very big and important decision that we're going to get from the judge that day, and we're going to be able to get our evidence and we're going to create our record, and we're going to that's the foundation, that's all the bricks, that's all the house, that's everything, right? So we got to build that up and take advantage of it, get our decision, and then we figure out what's next. So what's next? Next part of it is the appeals process. So basically, as soon as you get the decision and I touch the client and say, you lose, or yes, you win, then the other side gets to decide if they want to appeal or not. If we lose, we're appealing. If we win, then sometimes, if the department knows that they lost and they know they're not going to win an appeal, they can waive appeal. And if they waive appeal, then that means case closed, it is over, you won. They can reserve appeal and they get to decide, they go back to the supervisor, and then you get to sit with uncomfortableness for 30 or 60 or whatever days it takes. I don't remember it. I think it's 30 days. So you got your 30 days to be able to file your appeal. So you're waiting that 29th and 30 days, you're looking at the computer, wondering whether they're going to file the appeal. And if they don't, they don't, then you won. And if they do, then you got to keep on fighting, and it's going to cost more money and it's going to suck. But you just gotta, it's an advantage to have a win, be fighting to protect your win. It's harder to lose and to be fighting against the negative decision. So it's a big, important decision, but it's not the end of the story, right? It's like Yogi Berra said, it ain't over until it's over. And if there's an appeal filed, shit ain't over. So that's kind of the process. That's the overview from going from the NTA to the hearing notices, master hearings. Hopefully, if you're one of our clients, and we're going to be vacating those master 1 and master 2 dates, setting it to an individual hearing date, throwing everything out there, building that wall, DHS ripping it up, getting a decision from the judge, all the appeals. That's kind of the immigration court appeals process. Um, Lulu, I don't know whether we should take a spot there to check if any questions or whatever people are thinking. If not, I can kind of jump into some other stuff I got regarding, how to really separate yourself,
Yeah.
changes for Trump administration and detentions, but I can stop here if it's a good break point.
Yeah, and just in the time to get a water break there, and also for our translator. So far, it does not. I do not have any question. One just popped up. So, will the affirmative asylum cases have the same prep and process as an EOIR asylum case? And that's a question coming from Patsy.
Okay, so for asylum, like I said before, this is immigration court, right? If we're doing USCIS, which means usually that means they came over with a visa, right? They came with usually visitor visa or some other visa. And then while they were here, they weren't NTA'd, they affirmatively file for asylum. They say, we want to file for asylum. So within that first year of getting here, they file for it with immigration. You file it with immigration same way you would like a DACA application or like a work permit application. You just submit it to the service center, they process it. They're going to kick it over to San Francisco because that's who handles them all for this area. Now, when you go to San Francisco, it's very different because you don't have a judge there. You got an officer there. I haven't been there for a while. The last big chunk of asylees that I had were the Afghanis. I had like 20 of them. With the families, 40 or 50 of them, I don't know. But I had a lot of asylees, refugees and asylees that I did them for at USCIS in San Francisco. A lot of the people are former immigration attorneys, so they're favorable, you know. They know what they're doing. Um, the best part of it is that you don't have an ICE attorney there ripping you apart and trying to make you lose the case and trying to get you to trip up and making you freak out. It's very, very different. Um, when it's USCIS, when I go to that interview, it's a lot of it is just country conditions. It's just a whole bunch of country conditions with the declaration, and that's about it. You don't get experts, you don't get witnesses, you're not going to really have testimony. Um, you're just going to have a whole bunch of ID documents and some country conditions and a declaration with the asylum application. And then you're going to have an officer they're already going to know what's going on because they get the same educations just about that the judges do. They're going to know what's going on. They're going to know what's going on in that country. They're going to be specialists already, and they're going to have questions that they got um, for the client. It's pretty much going to be ripping through their asylum application. So um, the difference between immigration court and San Francisco asylum office, it's night and day. It's entirely different, and you can't really lose a case in the San Francisco office because they only have the ability to approve applications. If they want to deny it, they can't deny it. That's when you get the referrals to an immigration judge. That way the immigration judge can deny it. So you're not going to lose that day, you'll lose later on in San Francisco immigration court, but it's a very different flavor. It's a very different environment. It's a lot less tense. You can sleep the night before. Um, it feels much more like an adjustment of status interview that takes 4 hours than a confrontational situation like immigration court. So very, very different. Yeah.
I don't see any other questions in there. Still have time if you want to. If you have a question, you can use the little question box on the bottom of your screen. And our interpreter, if you have any, I don't think I have anyone that's fully in Spanish. If there's no question, you could also ask it in Spanish. We could translate that for sure. Y pues el abogado también habla español. ¿Y escribes también? No. I have actually an abuse of privilege here.
Mm.
For community members that don't understand the concept of, like you mentioned, that if they get their notice of appearance, or NPA as call it, is that something that gives, it's a paper they give to them, handed to them, or is it like a text, or what is it like nowadays, how they handle that notice of appearance? So if you receive say asylum family member, and we don't know what to ask, so we can start supporting them.
Yeah, first thing they're going to get is the notice to appear. The notice to appear, that's going to be handed to them, and they're going to usually sign for it. And if they don't sign for it, they'll put usually their thumbprint on there and say a refusal to sign. But it's going to be in a stack of paperwork. They're not going to really know that that's the most important document. They're going to have 20 or 30 pages. Some of it's going to be like, oh, here, this is where you can go try to get Medi-Cal if you're eligible for it. This is where you go if you need, free help for looking for an immigration attorney. Then mixed in there is a notice to appear. It's all going to be in English. They're not going to know what the hell they're looking at. So it's kind of just they're not going to know what it is, and they're not going to know how important it is. It's just going to be a random piece of paper with all their other documents. So usually you just got to keep it all together in a little packet and just be ready to show everything to the immigration attorney when you get it. Yeah.
Thank you for that clarification. And I see another question. Um, do you also prepare respondents for a se- SE final hearing?
Now, pro se is pro se or pro per. That's pretty much doing it on your own. If you do it on your own, you're probably going to lose, right? There are people that win. You can. I don't want to say it's 100% guaranteed. I mean, you'd be proving me wrong, and I'm wrong all the time. Um, but you're probably going to lose. So if you do it pro se, then the application usually going to have flaws in it. You're going to have flaws in your declaration, not going to know what to look for. Um, Usually what happens is you're not going to get much preparation for pro se individuals. We do have pro se clinics where we help individuals to file their own application, where we're not their attorney. We're not gonna take them all the way down that road. We're just gonna help them meet that 1 year deadline, just because it's coming up, and we want to try to help them out. But the legal problem is that we're on the hook for whatever work we do, or more importantly, what we don't do. So if we got somebody that says they're scared because of cartel, and they say they're scared because of cartel, and we put on the application they're scared because of cartel, and then they go to the individual hearing and they say, yeah, but it's because I'm gay, then the biggest problem is, why the hell didn't that attorney from Siren, heck, when you talk to, why didn't they write down anything about you being gay? Did they ask you? And they're gonna be like, no, they never asked me. And we do, but I mean, the biggest problem is exposure, and most attorneys are going to run away from a pro se. We don't want to know it. We don't want to see it. We want nothing to do with it, because we don't want to get accused of being incompetent later on by not helping the client correctly. So it sucks, but usually those pro ses, they're not going to get any help, and they're going to get very minimal advice. Everybody's going to try to keep them away and refer them out to somebody else, and they're going to refer them away and send them to somebody else, and they're going to keep doing that and show up unprepared and get their butt kicked in court. So it sucks, but yeah, somebody shows up pro se and they got an individual hearing and they just want me to prep them. I ain't doing it. I ain't doing
Right.
it. Yeah.
Okay, thank you. Um, how does the previous deportation order or voluntary departure affect an asylum case?
Two different things. Let's go with first the voluntary departure. So that means that you came in maybe in 2001. We're here, you got caught. They said you're going to get deported. Like, hey, I'm just going to sign off. I don't want to go through this whole process. Just let me go. Then they come back in last year and now they want to file for asylum. The biggest problem is, if you're claiming for asylum and you're saying, I'm scared to go back, why'd you go back voluntarily? So that's a big problem. I mean, it's less of a problem if you got beat to hell by the police for your political opinion 2 years ago. But if you're claiming that your whole family's been harmed and they've gone killed back in the 80s to the 90s, and all this violence has been continuing until now, then why the hell didn't you file for asylum the first time? Why'd you accept voluntary departure? Voluntary departures are a big yellow flag, sometimes red. So those can be real big issues, and that's going to be something that's going to come up, and you got to have good answers for that. So that's going to require you sitting down with your attorney, coming up with some really good explanations as to why you didn't file for asylum the first time. That can be a really big yellow flag or a red flag. The other part of it is, what if you got ordered deported before? Now, if you got ordered deported before, the problem is that you have a right to your hearing to speak to an immigration judge. If you've been previously deported, you already had the chance to file your case and you lost, and you already got a signature from a judge saying you're deportable and we're deporting you. So they call it reinstatement. Reinstatement means subject to reinstatement means they can get that signature from the judge from 1998. They're going to cut that signature out, put it on the new deportation order, and you're getting out, and you don't really get the hearing because you already had it. You don't have the same rights and due process rights if you've already had them and you've already lost and gotten deported. There's ways to get around that. There's withholding only proceedings. There's that's kind of like asylum on crack. It's that elevated level. There's asylum having fear, and this is more likely than not you're going to get harmed, tortured, something like that. Much, much more difficult. It's much more complicated, and you ain't going to find somebody nonprofit to be able to help you out with that. So that's not a yellow flag. That's a red flag.
I don't see any other.
One in
Do you have
the
another segment? And
I think panelist Siren asked about something. I don't know if you can see that
also,
question.
under what circumstance can a defensive asylum claim be transitioned to the affirmative asylum process?
No, that's not going to happen. That's not going to happen. There's always exceptions, right? Every single attorney knows with every rule there's an exception. Only exception that I can think of is it's TVPRA. That means it's unaccompanied minor. That means it's a 16-year-old that showed up at the border by themselves, got thrown in immigration court, and then they filed for asylum before they hit 18 in immigration court, and the immigration courts have held saying we're not going to put him through that jacked up situation of getting ripped apart by the ICE attorney on the stand with the immigration judge ripping him apart too. We're going to let those underage minors, those unaccompanied minors who came over the border by themselves with no adults, we're gonna kick them over and let USCIS just handle it. So that TVPRA is the only exception that I know of. There are some other circumstances if they dismiss the case. Sometimes you'll hear the word a dismissal, dismiss the whole NTA, and now you don't have a case with EOIR. Then you can file affirmatively. That's not being transferred or transitioned the way this one sounds like. I think that's not possible, but for the exception of TVPRA. But yeah, cool. All right, so I think we're good. I can transition. Next one.
Yeah, you could go to the next section.
Cool. All right. How to win asylum? What's the differences? Why are you going to lose versus how you're going to win? So, like I said before, country conditions. Everybody's like, just you got to see what's happening in my country. Check out a bouncing gun. It's terrible. Look at, oh, they treat gay people terrible in Iran or whatever. Yeah, that's true, right? That is always true. That, and you're not going to find an article that just says, hey, they treat these people badly. Give it to the judge, and the judge will be like, win, right? That doesn't happen. It's not about country conditions, it's about you. I always tell people you gotta shine, you gotta be special. What makes your situation special compared to everybody else who's in that circumstance, right? What about other people who are married that get beat by their spouses? What makes your situation different? That's where you really got to get into the dirty facts. That's where you get into if it's a DV case. I want to hear about all the times that you got beaten, but most importantly, when you fought back, when you told them no, when you pushed them away, you pushed their hands away from them. They tried to grab you and you say, no, hell no, that's not, no, I'm not doing that. When that happens and the guy goes over the top and gets even more violence, that's when he's not just going after the girl, he's punishing her for standing up for herself, for using the voice. That's where you got police officers. I don't know how these all, I don't know, I don't want to be jacked up, but I'm saying this is all my opinion, okay? We got this. I don't know how this happens in so many different countries all over the world, but it seems like all these asshole cops just all go to the same school where they learn to just go after gay people, and they always get them, and they always put the pistol to their temple and make them, give oral sex That is what they do, right? So all those dirty details, that separates you from somebody else that might be LGBTQ in that country, right? That specific harm when you told them no, when you said, no, get away from me. Hey, I'm gonna report you to the police officer, and then they get super pissed off and they want to impose their will on you. Those dirty little facts, that's everything. Because in asylum cases, we call it a nexus. You're not going to know what that is, but it's what a nexus is how you lose a case. Okay. If you can't show that the specific harm you got is connected directly to the harm that what you suffered is because of some specific set of facts, right? Because you're feminist, because you're gay, because of whatever they call it on account of. You suffered a harm on account of your membership to a particular social group. That social group is your political opinion or your religious beliefs. Well, not really those, but being gay or being a spouse of somebody who's machista, that sort of stuff, being opposed to cartels, whatever that stuff is, but you got to connect those dots. And the thing is, if you got a jerk who's beating on his spouse, he's not going to be like, I'm beating you, I'm beating, be like, I'm beating. Do you know why I'm beating you? It's because of your political opinion, because you spoke out against me 5 minutes ago and he said that. They don't say that. Okay. That's not real circumstance. Right. But when you have a police officer, he said, hey, mariposa. When he said, he's got, a wife and the guy's beating her up and calls her a slut and she's just a prostitute, but he doesn't say that to his spouse or his cousin. He doesn't say that to his sister. He says, you're my property. You're my wife. You do what I say. Those key phrases, that's everything. Because that tells you, it shows you the lens into their eyes. And you have to see it that in their point of view, they are punishing you because you are part of this group, because of your opinion, because you fought back, because you pushed them away, whatever it is that you told them. That's what makes and breaks the case. So those dirty facts that you get into, that's the good stuff. That's what we need to pry out. That's the most traumatic and probably troublesome part of it. But usually what I tell people is that if you've been through hella trauma, then no matter what questions I ask, no matter how much I got a client breaking down on the stand, like nothing that I'm going to ask and then put them through the hell that they went through before. So they can go through it. They've been through worse, right? So I just ask them whatever dirty, jacked up stuff they got to get out, just get it, get those facts out because in your closing, you're going to need those facts. So you need to give your attorney, you need to give me the ammunition I need to be able to shut that TA up, to shut that DHS, the ICE attorney up. So just be aware that you got to give your attorney that information. You got to give them that ammunition to be able to fight your case. Let me see what else. I think that's about it. Thank you. Next part of it is changes about the Trump administration. Okay. So we want to hit this quick because my understanding is we want to wrap this up within what, 10 minutes or so. Lou to this, if we get any other questions, just hit me up and wave or something like that. I want to get into a couple big things. First thing, let's hit the detentions first. I want to talk really quickly about that. Detentions aren't really happening in immigration court. I mean, if you got a bad crime, if you got a nag fel, talk to your attorney if you got really bad crimes, robbery or DV or rape or something like that. Those can be a problem, right? No matter where you're at. But for the most part, I have not heard of just about anybody getting arrested at immigration courts. That's not happening anymore. Well, specifically in this jurisdiction. So when it comes to Concord, San Francisco, nothing that I see is coming out from there. Sacramento, I heard one of my colleagues just posted on Facebook. She saw some ICE officers on the second floor there last week, but it's very rare that I see individuals like that. Usually the people with prior deportation orders or crimes. But for most of our clients, they're going to be clean because that's where I take them. So they're not going to have to worry about any of that. Let's talk about the Trump administration problems. We got 10 minutes to hit this. There's two big things that happen with Trump. One of them is so-called matter of car. Matter of car said if your asylum application doesn't within the four corners of the page, right? It's kind of like in contract law. You go, whatever's on those pages that you got, those 12 pages on your asylum application, if immigration says all of it, we don't argue with any of it, all of it's true, Your Honor, take it as all perfect truth. That's still not enough to win asylum. So just deny the application without even having a hearing. The judge can do it, and the judge will do it. And they have denied us a lot of applications that way. That can be just not putting the passport information on there. That could be putting the biographical page of the passport and not putting every single page, every single blank page, and the front and back of the passport. You need to put it all on there. If you don't put it all on there, then guess what? It's getting denied for matter of car. Okay, because from the judge's perspective is, what if on that passport it's got exit stamps and it says that you went to Costa Rica for 2 weeks and you voluntarily came back? Why the hell did you come back to Guatemala? Right? You should have filed for asylum over there or just came straight to the US, but you voluntarily went back there. That could be bad. And if you don't show your entire passport, I mean, what are they going to do? They're just going to assume the worst about the pages that are missing. Okay, so everything that you get submitted needs to be translated. Everything that you submitted needs to be clear, and you need to make sure that everything on that application adds up to an asylum application. Because if you just say, hey, I got scared and I got hurt, and these people tracked me down and they hurt me and I'm gay, if you don't put in that nexus information and say, yeah, they called me mariposa and they said they're beating me and they beat me because I'm gay, then the attorney for ICE can just say, hey, they didn't connect the dots. There's no nexus there. Deny it for matter of car, and they will. So got to be really careful this matter of car stuff. It's something that a lot of judges are using to just summarily deny applications without giving anybody the proper hearing. And the most jacked up part is that this wasn't in existence before. Everybody puts skeletal applications and files them, and then they move the goalpost. So that's just dirty, but that's the way it is. The bigger issue that's been popping up is something called pretermission. That means that there's ACA motions. They're pretty much saying that, hey, we could deport you. We got agreements to ship you off to Honduras or Guatemala or Uganda. And if you can get deported to one of those places and don't claim asylum from Uganda, then we can order you deported to Uganda, and it doesn't matter whether you can get beaten and raped and left for dead in a ditch someplace in your home country because you got Uganda, right? So it's illegal and it's wrong, but that's what's been happening is they say, okay, well, since you can go to Uganda, and Senator Rubio is saying that he will take you to Uganda, even though he really might not ever actually do it. If it's possible that he can, then they'll just completely deny your application without ever looking at it, without deciding whether it's real application or not. They got some very, very dirty situations, gay people just getting, tortured because of their sexual orientation, and what's going to happen to them is evil. And they're like, no, there's Uganda. And then they deny the applications and order them deported. They don't actually have to deport them to Uganda. They just have to deport them. Maybe they send them to Uganda. Uganda sends them back to their home country, right? The US isn't doing that. So a lot of dirty, dirty stuff going on there. They also moved the goalposts and said that if you get a pretermission based on the ACA, hey, you can get shipped to Uganda or Guatemala or Honduras or wherever, that you don't get the full amount of time. You don't get 30 days to file an appeal. You get 10, and you get an expedited processing to be able to get your decision slapped down by the board quicker. That way you get a more firm denial and quicker to get deported. All these things are going to federal court, and that's just a whole different webinar that we could get into. But it seems like that's kind of starting to go away. There's court cases challenging this. So I don't hear it as loud anymore as I did 2 weeks ago. So it seems like things are starting to change, especially with the what is it, the dog killer gnome. Since she's gone, I think it's also changed a little bit. So
No.
not sure whether pretermission is really a big thing anymore, but we'll keep an eye on that. Now, when it comes to pretermission, just be aware that there was a BIA, these new BIA expedited trying to deny people their procedural rights and get them deported quicker. These protocols are in place, and those protocols are effective as of March 8th, 2026. So as of 8 days ago, they started doing this expedited processing to get people out quicker and deny their asylum quicker, and just violate constitutional rights quicker on a more expedited, convenient way for the government. So that's in effect of March 8th. So that's happening now. Okay, questions?
We have no questions. I do have a question. Is there a difference of what an asylum seeker should look for, especially if they're in the Black community or a community of color, that as family members we should ask, like while they were coming coming over or where they were looking for that asylum petition or request via the app? Is has we know that there's a racial bias and unfortunate, strict racism towards people of color, especially Black community.
There is some. Sounds a lot like one of our cases, and we'll talk about that. What I've seen is yes, there is more, but it seems like what it feels like is more negative treatment towards either, Black people or LGBTQ, is what I'm seeing. Um, that's just based on my personal what I've seen. I've not talked to anybody that can verify that, but that's what I've seen. Um, what it seems like to me is that it's not so much based on race or LGBTQ community. There's a big, huge target on people who are Muslim. Muslim is that's a red flag for Trump. He hates Muslims. So I mean, he hates everybody. He hates anybody that's of color. Hates anybody that's an immigrant. Being darker you are, worse. More Muslim you are, worse. So um, yeah, I don't think it's so much anything that you can say or issue spot. It's just it's they just have to be aware that they need to understand that they're probably gonna lose because that's the way it is, and you just have to keep on fighting. Like I said, Yogi Bear quote, it ain't over till it's over. With plenty of these, you can fight them, lose, and then take it to appeal. And sometimes your appeal, I've had appeals take 2, 3 months. I've had appeals take 2 to 3 years. So if it takes 3 years and you get an appeal, for a denial later on this year, then all of a sudden maybe when your appeal is exhausted and you lose at that level, then maybe you have a President Newsom, maybe you have a President Harris, maybe it's a different world. So I just tell people, if you got a case that's a loser of a case, there's been plenty of those situations where I'm 100% sure the client's going to lose and something changes at the end. So just keep fighting until if you're still here, keep fighting. And sometimes even after.
Thank you. And we have no other questions. You can proceed.
Cool. Okay. Nope. That was it for me. Um, so that's kind of a summary of what it looks like for, seeking asylum, what it looks like from the start to beginning, from all the way from getting stopped at the border, NTAs, the calendar hearings, the individual hearings, all the evidence, all the, bad stuff that you got to get into and flush things out with your attorney. Make sure you're communicating well with your attorney. Definitely hope that we can, get a copy of this and ship it over and text it over to every single one of our clients that have hearings coming up because they need to hear all this. So just be aware that this, the moving post with the Trump administration, that's going to be a constant. We got 3 more years of this. He's very much doing the same thing he did last time, which is changing what to expect, making things harder, making things more tricky, changing forms at the last minute, changing payments at the last minute, just making it harder for people to represent themselves or to have their attorneys represent them. So just don't worry about it. Just roll with it and keep on fighting.
We
Um,
do have one, sorry, we do have one question just walked in, anonymous. Can a person who wins asylum ever visit their country?
Generally, no, but yes. So if you go back to say you win asylum, right? So the general rule is don't do it, right? Because on your way back, then they're going to ask, why the hell did you go back? You just said you were fearful for going, and then you're going back. Like you better have a really good reason for it, right? Maybe something changed. But the main question is going to be, well, did you lie? Did you lie when you said, oh God, I never want to go back again? And the judge is like, okay, God, no, I'm not going to send you back. And then you get on a plane and you go back. If you think that you're safe and they can't retake that shit back, then you're wrong. They can. They can reopen the case and remove your benefits. The safer route is to wait, get your residency. Then once you get your residency, don't travel there. And then just get your citizenship. And it's harder to rip apart your citizenship and take that back. But the biggest way to take away your citizenship is, of course, fraud. So yeah, they can still take back the citizenship and take that back too. So can you go back? Yes, you can. Is it always going to be risky? Yes. And I'm never going to tell people to go back. If you want to go back to go see your family and you're from Honduras, then I'm going to tell me tell your family go to Costa Rica and you meet them there. Do not go back to the country there. You have to get special permission to do that. And even if you have that special permission, it's not a guarantee you're going to get let back in when you get that. So yeah, you're going to get a lot of conflicting information on that.
Thank you. I do have a question. Last one. I don't know
Mhm.
where we're at with time. We're at 6:30. What
We
time?
started a little late.
Yeah, no, I think we're good. I think we're good. I'll ask you later. Well, Joshua, thank you so much. It's very insightful, and I really appreciate your candid and honest, approach to letting us understand the clarity that is needed, for us to help ourselves and be able to give our legal team a good, solid case, so that way they just have to maneuver, what's going on at the courts. Um, we will have the third and last series of this three-part series on next Tuesday. We will be emailing you. We have this recording. We'll probably be making some content with this important information, because we do know there's a lot of uphills battles still happening on immigration, and especially in these cases. Again, thank you so much. We appreciate you and giving back your time. Have a wonderful evening, and